It's not often that you get to kiss the person who introduces you when you're about to do a CLE. So that's a nice thing. So thank you. I am very pleased to be here. And every year we kind of think of a topic that would be interesting and topic or timely. And I think this one is particularly so in the sort of timeline in which we're living. I titled this "Clients Run Amok. What are you going to do?" We all have had experiences with clients who are perhaps challenging, and so there are ways that we can manage that. But I wanted to kind of put that into context. So lawyers have a broad range of responsibilities to our clients, obviously, including heeding their desires to do the best, to do our best to achieve their goals. Sometimes those goals require us to challenge the law, to push some boundaries, to seek change, to maybe, seek for modification or, some sort of out of what we think of as settled law bounds. So it's sometimes our job to help our clients challenge the law in an orderly manner. But what do you do if your client wants to skip the orderly part? So, poor misquoted John Adams. Most of us have heard the quote, "We are a nation of laws, not of men." And that is actually not accurate. It's not exactly the quote that's in the 1780 Massachusetts Constitution, which was attributed to him. The quote is actually, "We are a government of laws, not of men." And it's a subtle, but I think important distinction that I can kind of frame the conversation we're having today. I think it's more accurate rather than saying we're a nation of laws, which was the inaccurate quote, to say that we are a nation of norms, not of men. A nation includes its government by definition, obviously. So it's probably accurate to say that we are a government both of laws and norms. And therefore, we as lawyers are stewards of both those laws and norms. So the structure of the law and norms, obviously, we know law is comprised of substantive and procedural rules governing behavior, right, of the citizens and even non-citizens of the United States. And the norms are the guardrails on how those substantive rules can be challenged. So we know as a free nation that we wanted to give some flexibility and sort of opportunity for citizens to challenge the law without worrying that the government would seek retribution. And we as lawyers are the people who help them do that, but we know that must be done in an orderly manner. So laws and norms lend us stability in the social and legal compact that we have with our clients and with our society. We lawyers understand that challenging the legal structure requires adherence to those norms. They may not be written down, but we know that if we don't do things within a certain orderly, understanding, then we will start to lose the ability to sort of shape the government and the laws in a way that's useful to our clients and predictable. But when our clients don't understand that, we're in an ethical bind. They want to push those norms past the breaking point. It puts us in a position of having to deal with their desires, and the rules don't necessarily give us all the tools we need in every circumstance to address that. So we've heard this term a lot recently. I assume most people have heard it. Times are changing, and we have heard this expression that Mark Zuckerberg created in his early years at Facebook, which is the idea that innovation is couched in terms of disruption, and the way to change and evolve is to move fast and break things. The culture is rapidly expanding. The move fast and break things culture is expanding in every sector of America. And we represent clients who are influenced by that culture. So they see what's happening in all facets of society, and they may think, that's a good way to go about their whatever their legal goals are. So we know stopping change won't work. We don't want to stop change. Lawyers are arbiters of change in some circumstances, and we are stewards of change in many others. But where is the line between constructive evolution and total destruction? So, where are our breaking points? We know from the rules that the clients can ask us to challenge the law, and we can certainly agree to help them. But we also have some help in the rules to sort of delineate to our clients what we will do for them and what they can control in terms of our representation of them. And that is that the client controls the ends. The client controls whether or not to settle, whether or not to take a plea deal, how much money they want to push for or receive, and they could say no to signing a contract, of course, but the lawyer controls the means. So how the contract is drafted, the relationship with or adverse to opposing counsel, how litigation is comported, is within the lawyer's control. Sometimes the line between what the client wants to push for and what the lawyer is comfortable doing is easy. If the client is pushing hard for something that requires us to violate our confidentiality, rule, or maybe allows us in the exceptions to tell the client no. That if you want to do that, I have to reveal, or will not have to, may reveal that confidence because you're putting me in a position of helping you hurt someone. Candor to the tribunal. We can say to a client, I need to be honest with the court and I will not do whatever it is that you want me to do. And then there are rules of evidence. Lawyers can't be compelled to testify on behalf of their clients. So if a client's pushing for something improper in that regard, you can say no. But the rules are usually most helpful in fairly extreme circumstances where a client is really pushing not just the norms but the rules, and really seeking to perhaps break the legal structure that we know, and is more clear than perhaps those sort of proper ethical norms. But the problem is not all calls are easy, right? So to the point, it may not be that your client is asking you for help in hurting someone. They're usually a little more clever than that. But they might be asking for something that's not clearly unlawful at the time. So the examples I have here, the Enron scandal was what later spurred Sarbanes-Oxley, was not technically necessarily unlawful when it happened. So Enron, you may remember, was the lawyers and accountants representing Enron back in the day. They were using dubious accounting tactics that weren't necessarily unlawful at the time, but were likely violating norms at the very least. And they were having lawyers write letters to sort of validate these dubious accounting practices. So they're pushing the boundaries of the law. The lawyers get on board by saying, well, we're not going to go all the way, but we'll kind of write you an in-between letter that makes this look like a valid transaction or movement of debt off the books, and it was not, or at least it wasn't unlawful, but it was pretty clearly harmful because a lot of people were pretty badly financially damaged in that situation. To Omaha? Do you know they started here?
Exactly.
Yeah.
I think it's possible they may make a rebound.
I doubt it. So the point is that at the time, it was really sort of innovative, right? Move back, move fast, break things. That was pre move fast, break things. What's that? Ken Lay? Yeah. I think he's in jail, isn't he? Yeah. Or he died. Okay. Yeah. Yeah. So another example, tobacco companies. back in the 1970s, the tobacco companies were facing the reality that the science showed that there was a link between cancer and tobacco products. And so what they did was they created a scientific study group within the company that would study the link and then would report that information to the in-house or hired counsel for the company. And so counsel took rule 1.6 and the rule of confidentiality and would review the report. And if it had negative information about the link between tobacco and cancer, they would park it in a drawer and say that's confidential information. If it was positive, there was good news, then that could be released, and the lawyers would say green light. So that spurred the exceptions to Rule 1.6 that allowed lawyers to release information that was damaging to the company if it would physically hurt people. But here's still the gray area in that. Could you still say that what people, is there a specific threat? When we know that there might be a link between tobacco and cancer, we don't know who precisely will be harmed. And lawyers could still say, well, I don't know, maybe this is still confidential information. But lawyers were being used by clients in that gray area of the law to bury that information. Didn't work out so well because during the tobacco litigation, ultimately they were required to reveal those memos, and those were the smoking gun memos that really buried their arguments that they were, it really made it hard for them to be successful in that litigation. And then again, now we have more current example in the election fraud arguments brought by the 2020 Trump election or campaign. There were several sanctions proceedings for lawyers in many of those cases because through Rule 11, because of the 60 cases that were filed, not a single one was deemed to be valid, essentially. And lawyers were pushing arguments that were determined to be either lacking legal basis and or factual basis, and therefore were essentially considered a harassment or in violation of Rule 11 because they were wasting the time of the courts. And so it's not necessarily that those lawsuits on the front end would be considered problematic. You could maybe make the argument that we have a reason to believe that we can seek some sort of relief in the courts. But in the end, it turned out that the courts were inhospitable to those claims. Right. So why weren't those easy calls? In those circumstances, the clients were very powerful forces, and they really didn't have clear boundaries. There were not necessarily clear rules showing the clients that the lawyers could say to the clients, here's the rule, I can't or won't do that because it'll put my license at risk. But norms, which we know are not laws, do provide some perhaps fuzzy boundaries. They're not as clear as the rules. And sometimes the clients, don't want us to break rules or laws, but they do want to push boundaries. And, we see this somewhat regularly. We have a client who perhaps wants us to refuse all rescheduling requests, even when they can be accommodated, requesting remand of a judge for specious reasons, maybe a document dump during discovery that's much bigger than it needs to be, with a good number of documents that are irrelevant or outside the scope of the discovery request, changing significant draft contract provisions without track changes, drafting onerous lease agreements that do little to benefit the landlord but make compliance difficult for tenants, things that might be weighted on one side's favor and do some harm to the other side but aren't technically disallowed. So we have some rules-based options. What can we do when our clients run amok? So here's where you could say, I can't. I've got a rule, and I'm pointing to it so that I could say I've got backup in this decision. So we have counseling, right? Rule 3-501.4 says it has to do with communication with the client, and basically says that lawyers should help clients understand what the law is and how the law works, communicate with them about our responsibilities and theirs, and help them make informed decisions about the ends that they have the control over, and that explain also how the lawyer has control of the means, right? So I understand you might want me to do XYZ, which would sort of be improper. And I can't do that because it would push me. You know, you're kind of invading my responsibility or my right to control the means. Um, this is actually bolstered by a story. I was recently talking to a judge who said, told someone had asked, "What's your experience with sort of legal briefs at different phases of your career?" And she had an interesting response, which was she spent 20 years practicing law. And in those 20 years, she wrote obviously, a lot of legal briefs, and she felt very good about them. She felt like they followed the rules. She had, she worked hard to make them read easily and follow the dictates of her legal writing professor from law school. And she had all, the legal arguments there that she thought would be the most useful to her client. She never felt like she did anything that wasn't positive. But what she said when she became a judge is that she really realized quickly that what her goals were when she was practicing were different than what her goals were as a judge. And when she started reading briefs from that side of the bench, she realized that she wanted briefs to be written in a way that gave her all of the tools that she needed to make a decision in favor of one party or the other. So that her best briefs that she was reading as a judge were the ones who gave her all of the information that was maybe adverse to to that party's position, but dealt with it in a way that she could then use in her determination, or had a list of all of the cases that were relevant with helpful and very properly sort of cross-referenced citations so that she could pull those and put them in to her legal memoranda. She also said, cites to the record that are precise, which are often lacking, or the most important things that she could ask for as a judge. And the reality is that that's not necessarily what we do as lawyers, because we're trying to make sure that our clients see that we are advocating for them in a very, sort of uh, zealous way, right? So we're not necessarily doing the very simple and less flowery brief for the judge, right? We're doing it for the client, but the judge is the one making the decision. So the norm there, where our client might want more incendiary language or might want a better argument, stronger argument, or a certain argument in a certain position, is not necessarily going to help them when it comes to the judge's determination. Um, Obviously, Rule 1.2, which we just discussed, which is the lawyer controls the means. Withdrawal is an option if a client is really pushing for certain behavior on the lawyer's behalf, and the lawyer just can't get there. You could seek to withdraw, but the problem is the withdrawal rule has limitations, as I'm sure you all know. It has to be because your client is seeking help in criminal or fraudulent activity, whether if there's a conflict of interest, and that can include ethical considerations, so that can be helpful, or if the client insists on taking a position the lawyer finds repugnant or with which the lawyer has a fundamental disagreement. So again, that's a little bit more sort of meat to rely on if a client is pushing too far, but it's not something that lawyers want to do. Say, you are pushing me into a position of a fundamental disagreement. Instead, we want to be able to work with our clients to get them what they're looking for, and get them to the place that they need to be without necessarily pushing the norms past the breaking point. And then, of course, Rule 11, lawyers need to refuse to file pleadings that are meant to annoy or harass. We see this in SLAP litigation where people might sue um, protesters of, say, a golf course that the protesters don't like the environmental impacts of the golf course. And the protesters might be sued even though they have a First Amendment right to protest. The litigation is expensive and takes a long time, slows things down, but it's not necessarily, uh, it's not necessarily going to be successful because people have a First Amendment right to protest. But you see, these potentially like borderline Rule 11 situations that someone could seek those sanctions, but we know those aren't very common. People don't want to bring Rule 11 sanctions against opposing counsel. So these rule based options are more for those extreme examples and not when the clients are pushing norms. So we have two other options outside of the rules. We can be, on one hand, we can just give in, right? We can give the clients what they want. If they say, I want you to break norms, and you say, okay, I guess we'll just deal with the reputational and structural consequences to the law later. You can do that. Again, these are situations where it's not clearly a violation of the law to work with the client, right? To do what the client wants. Or what I've just made up, I'm trying something to get this into my brain and maybe other people's brains too, which is this idea of noisy norming. That we as lawyers are in a position to be able to help our clients understand what the norms are. They don't necessarily know how lawyers interact with one another or with the courts outside of those rules. Certainly, they might not even know the rules themselves. But explaining to the client that their reputation and your reputation matters, because ultimately the decision is going to be made by a trier of fact who is not interested in making the client feel good. It's the trier of fact is someone who's trying to get it right, who's trying to decide the law on the merits and get to the right conclusion. And if you can bring your clients along and maybe bring them inside the circle that we are in as attorneys and tell them that it's actually strategic to be less strident, perhaps. And, you want to stand up for them and do the best thing you can for them. And that is following some of these norms that we have kind of chosen to engage in, dialing down the difficult interactions that clients may demand, and seek to work toward some sort of resolution that is, I'm not saying give up on your zealous advocacy in any way at all. What I'm suggesting is that you can see that your representation of your client can be done in such a way that they actually feel like you're working hard for them by being someone who engages with the norms and wants to uphold those norms and is someone who seeks stability in the law instead of seeking to move fast and break things. So I think of it in terms of moving thoughtfully and challenging things, right? That lawyers are part of the foundation of the law in this nation. We have a responsibility to a stable government, which leads to a stable nation. And if we engage with those norms, we will uphold and stand with the rule of law that we all took an oath to uphold when we became lawyers in the first place. So noisy norming, right? Be very clear with your client what your understanding of the norms is and why you think that the best argument might be the one that's maybe not as satisfying. It doesn't necessarily scratch the itch that they want to scratch, but that ultimately they'll be more successful if you engage in this normative way. So in conclusion, and maybe I'm a bit hyperbolic here, but in the context of legal ethics, it may sound like hyperbole, but considering that lawyers were the ones who built this republic, And the republic is a nation of laws and norms. We seek to protect, as lawyers, freedom. We seek to advance fairness, and we provide stability. Modern day lawyers can continue that tradition that our founders built at the beginning of this nation, and we can be stewards of that legacy. And Justice Sotomayor, this is just 6 days ago, actually said, once norms are broken, then you're shaking some of the foundation of the rule of law. These two things are inextricably linked, and we lawyers we're the gatekeepers. We're the ones that make access to the laws and to the government possible for many, many people in the United States. And that can be whatever form you practice. So let's be stewards of norms to shore up that foundation. Thank you.
Thanks, Professor. What I thought we would do is we're going to have one more speaker, our guest speaker, which is Judge Susan Bazes, address the group. And we're going to take a break for about 10 or 15 minutes, and then we'll come back for the McGrath North section of the presentation. So without further ado, it's my pleasure to introduce District Court Judge Susan Bazes to talk today. She's a graduate of UNO, magna cum laude in 1990. She was a graduate of Creighton Law School in 1993. She was in private practice before becoming a county court judge in 2007. She became a United States Magistrate Judge in 2017 and kept that position until the time she was nominated and received her commission as a United States District Court Judge. She's swearing in on April 10, 2024, so we're coming up on our 1-year anniversary as a judge. She's taking the place of John Gerard, who's no longer on regular status. He's taken senior status in Lincoln, so Judge Bazes will eventually be in Lincoln, replacing Judge Gerard. It's my pleasure to introduce Susan Bazes to talk about whatever she's going to talk about here.
So good. Good afternoon, everybody. All right. So obviously in the agenda, it says how to ethically practice in federal court, but that seemed a little harsh a little bit, which I know we're here to talk about ethics. So what I want to talk about is what you should be doing in federal court and give you some things to think about in order to avoid any ethical situations that may arise based on working in federal court. And as our previous speaker talked about, there are rules and laws that apply, and federal court certainly likes those. There's no question about that. And if anybody has heard me talk before, the first thing we're going to talk about, oh, maybe not. There we go. So what to do in federal court, and that is to read the court rules, and not only the federal rules of civil procedure or criminal procedure, but our local rules, which expand on that. Because there is not a lot of leeway in regards to those rules. Now, you can talk to opposing counsel and see if, for example, you want to extend a deadline. And if you agree to that, just make sure you make that request before the deadline expires. Once the deadline expires, we are really, as judges, have to look at good cause. And if it is not there, we can't extend it. And if we do, your case is subject to being reversed by the 8th Circuit, who strictly enforces those rules. So it is imperative that You be aware of the deadlines and you meet those deadlines. And if you can't, talk to opposing counsel, number one, to see if you can come to an agreement, but also think about what the other side may be asking for a couple of reasons. Number one, you may find yourself in a situation where you need a continuance dealing with that same lawyer or someone from that lawyer's office. Number two, is it really worth objecting to? And as we talked about previously, your client may want you to object. But I think you have to have a conversation of, does it really make sense in this situation? For a couple of reasons. Number one, when you file a motion for an extension, you need to indicate whether you've talked to the other side and whether they have an objection. If you're asking for a 3-day extension and the other side is objecting, I'll be honest, the court is like, why? What's the issue? Honestly. But the other thing you have to remember, and this may be a good time to talk to your client who may not know the rules or understand the rules. If a request for a continuance is made and there's an objection, the other side has 14 days to file a response. So now a 3-day extension has turned into a 14-day extension, which then just delays the case. So you're going to hear me talk about today a little theme through here of whether it's really necessary. Is it something you need to object to? And or is it maybe something you can compromise on? And there's a number of reasons to do that going forward. So just think about that. Now, the other thing about the court rules is we do update these rules every single year. And we do send out an email asking for feedback. Is there a problem, a concern that you're seeing with the rules? In particular, if we've changed or updated something, is it really working? Is it not? We want to truly know that. And we have a whole committee that works on that. And then the new rules go into effect December of each year. And so keep that in mind. If you're seeing something that doesn't work, Judge Bisher heads up that committee. You can either email his chambers, you can email me, I can get it to him and the group that works on that. But we do really want to make sure that things are working, obviously, not only for the courts, but for all of you and the litigants that come before us. And one of the big changes last year was their artificial intelligence, obviously, which is getting bigger and bigger. But we did implement some rules in regards to artificial intelligence. You now are required for all of your pleadings to do a certification of compliance that either one, no generative artificial intelligence program was used in drafting the document, or that to the extent such a program was used, a human signatory, so whoever signs the document, verified the accuracy of all generated text, including all citations and legal authority. So whoever is filing it and signing that document is responsible for everything in the brief, which we know you are supposed to be. But you do need to make sure that those cites are accurate. And I will get back to that in just a minute. So the next thing I want to talk about is civil case management practices. And at the end of this presentation, I'll show you where you can find that. The magistrate judges, through an attorney forum and getting feedback from lawyers, created the case management practices. That is how a civil case goes through the federal courts. It answers between the court rules and the case management practices. That should answer just about every single question that you would have in regards to a case in federal court. And there are also criminal rules as well. So when I'm saying rules, I'm talking civil and criminal, but the case management rules are for civil cases in particular. And all of the magistrate judges, it's the same for all of them. So when I started, there were certain rules for Lincoln and certain rules for Omaha. Listening to the lawyers, that was very frustrating, not only for them, but their clients. And so we worked to devise a plan. So it is all civil cases are progressed the same, whether you're in Omaha or Lincoln, and it doesn't really matter who the district judge is, except for when you get to trial. Each judge has their own little trial rules. But other than that, the case is the same. And so the rules and case management practices really will answer all, if not the majority of your questions, if not all of your questions. And the local rules will answer questions such as, how much time do I have to file my brief? Does the motion need an accompanying brief? Do you need to submit a proposed order to the judge? Is there a page or word limit for your brief? Because we did implement that a few years ago. And all of those and more can be answered by the court rules. As to the case management practices, it will tell you the Rule 26F report, how that's supposed to be done, and the things that you do need to consider in regards to that report. When scheduling conferences, because the court will schedule a scheduling conference, how and when that will probably happen, and what you need to do or how you can communicate with the court if you need to have a hearing with the court or a conference with the court. It talks about discovery practices and discovery disputes and what's required, mediation and settlement conferences, as well as the final pretrial conference, and if you consent to a magistrate judge and what that's going to look like. So really, between the rules and the case management practices, you can get all of your questions answered. However, if there's something after reading the rules, case management practices, something's not clear, you don't understand, you need a procedural question answered, you can contact the court. And generally that would be done through the magistrate judge, who can either their staff or clerk can answer that question, or if need be, can get on a call with the parties in order to discuss it so the case can keep moving. The next thing in federal court, which is really important, is the meet and confer requirement. We do require that before you contact the court with an issue. And all of the judges mean a true meet and confer. And what that means to us is email is not enough. You need to get on the phone. There's a lot of things that can be misinterpreted by emails. And I'm going to caution you here. Please remember, any email you send may end up in front of the judge. I cannot tell you how many emails I have seen between lawyers in regards to discovery disputes when I was a magistrate judge. Almost every single one I got emails. And it would be my guess the majority of them would think I would have never seen them, because probably not the most appropriate interaction between the lawyers, I'll be honest. And I understand you get frustrated, but just remember it may end up in front of us, and it's not something we, quite frankly, like to see. So, but we do, most of us do require, well, all of us do require that you talk on the phone and you can talk it out, because sometimes through the emails, you're not hearing what the other party is saying. And through those discussions, it seems to really help or narrow the issues. So then when it gets to the court, it's one or two things rather than 10. Again, which helps keep your case moving. In regards to meet and confers, so really the first time you're going to meet and confer is the Rule 26, and obviously if a motion to dismiss is filed, a lot of times the lawyers are not talking in regards to that. But sometimes it may be helpful if the motion to dismiss is filed, the other side wants to file an amended complaint. Can that be worked out in order to keep the case moving? So I do encourage the parties to talk. Also, during those interactions kind of sets the tone for the remainder of the case. And when there's a lot of animosity in the beginning of the case, that tends to carry forward. And unfortunately, then the court sees that through the discovery disputes or motions to compel that may come later. So encourage you to talk and try to hear what the other side has to say, because the reality is no one is going to win 100% of the time. There needs to be some compromise. And in doing that, you can keep the case moving and keep your clients happy that it's moving and it's not stalled. Now, the other thing about the Rule 26, and some of you have probably heard me say this before, it's not a drive-by, meaning it's not, okay, we got to do this. We think it's going to be, we can get this done by this period of time, which I know those are the conversations, but you need to have fruitful conversations. And I'm going to talk about ESI. Our case management practices tell you what to talk about in regards to ESI and get that decided up front. If you can do that, it will be tremendously helpful, not only to your client, but to the court later on, because I will tell you, if you come to me or as a magistrate judge, when you came to me with an ESI dispute, my first question was, did you talk about X, Y, and Z? For example, search terms. Where were the items located? Who were the custodians? All of those sorts of things. And most of the time, the answer I got was no. And I realize you might not think it's a problem, but once you start talking about, then those problems develop, or it leads to other questions. And so it can really be tremendously helpful. And that's why we took the time to do it and put it in the case management practices. So it could either avoid the discovery disputes or narrow it to one or two issues and not the whole range of ESI. So again, I just want to emphasize the Rule 26 is not what I call a drive-by. It's there for a reason. It will be the map of the case. It tells the magistrate judge what time, how much time you need and why you need it. And then when you start asking for continuances, then the question is, well, why do you need it? Why didn't it happen? And if it is, well, we didn't really talk about that in the beginning, that's not really the best reason for the continuance. We all understand things happen. There are things that people do not anticipate. But if you've truly taken that process seriously, then everything can flow a lot better. So just keep that in mind. Discovery disputes. You cannot file a motion to compel in the state federal courts in Nebraska without meeting and conferring and trying to work it out before getting the court involved. If you file a motion to compel, and you may have written a really long brief, that's all great and fine, but it's going to get stricken automatically because you didn't contact the court first. We try to do discovery disputes either at a hearing, telephone, Zoom, in person, but generally we're doing it on the phone or in Zoom. We do have a lot of attorneys that are out of state in federal court. And the hope and desire is, because if we can resolve that, then again, your case can keep moving. If it's a motion can compel, once it's ripe, I mean, you're looking probably 60, 90 days at the earliest for a decision. We all try to get our orders out within 60 days of a motion being ripe, 90 days at worst. But one thing you have to keep in mind is 50% of our docket is criminal. We have a huge criminal docket here. And unfortunately, that takes precedent over civil. So, and we are expecting that criminal is going to increase based on the current administration. So we do expect to get busier in that regard. So just keep that in mind. So really what our goal is to get those decisions done as soon as possible. And then we can keep moving with the case. So do try to thoroughly talk through that discovery dispute and issue, hear what the other side is saying, and see if you can reach a compromise. I understand sometimes that just can't happen, and the magistrate judges are there to help you in that regard. But if you truly have not met and conferred or talked about it, we know about it. We can tell pretty easily, either through your email, and we'll tell you to go back and meet and confer, or once we get on the phone. And if you haven't done your work, it's really hard for us to do our work. And obviously, you know the case better than we ever will because you're immersed in it. So just keep that in mind. The other meet and confer is the pretrial order that you are going to submit prior to having your pretrial conference with the magistrate judge. Again, that is not a drive-by. There are significant rules in regards to that. For example, if you don't list an exhibit on your exhibit list, it's not coming in at the trial. It's done. If you haven't listed a witness isn't coming in. You're not having that witness testify at trial. So if there are things that are not included in that, there can be significant ramifications for your client and for the trial. So keep that in mind. If you don't have an objection listed on the exhibit form, that exhibit's coming in, your objection is waived. So there are significant rules in regards to that can impact the trial tremendously. So you need to take that seriously. The other thing I would say is this. Our rules provide that at the time of the pretrial hearing, you should be ready to try that case the very next day. Our goal is, by having you do all of this, is to make sure that you are ready for trial, and all of the cases are set for trial, and you know when your trial is. And I think sometimes what people think is, well, I don't really need to worry about it. We'll get this done, but then I'll get working really hard on it a couple weeks before trial. And it just doesn't really work that way, or very smoothly that way, I will tell you. So keep that in mind, because there's a lot of questions that the magistrate judge is going to ask you that you better be ready to answer. And again, the district court judges are very busy working and trying to get all of their orders out, as well as the criminal matters that we're dealing with. And so if the more thorough you are with that, the pretrial report, obviously the smoother the trial will go. So just keep that in mind in those meet and confers. And really the purpose of the meet and confers too, as well, are to develop that relationship between the lawyers. And you can see the ones that really get along and how they can make compromises for the sake of their client and getting the case either to trial or resolved, and those that don't. And you can see the delay in the case. And I think most clients want a just, fair, and I don't want to say speed of light result, but as quickly as possible, and to have it be thorough. And you can do that by conferring and obviously trying to work with the other side, because these cases take years to get to trial. We want them done within 3 years, and most of the cases we can get done within that time frame or earlier. You are fortunate in this district. If you want a trial, you can have a trial. We can accommodate a trial, whether it's civil or criminal, quite frankly, anytime you want it. It's just a matter of when you are ready for it. So keep that in mind. Now, content of filings. And Professor talked about this a little bit, about what your client wants and writing a brief for maybe what the client wants versus what the court wants. And I'm going to talk a little bit about what the court sees. And I'll be honest with you. I've been a judge for a long time. And what I see is not getting better. It's getting worse. I struggle and try to figure out why it continues to happen. And I see it more and more. And so a couple of things. Citing a case for a proposition it does not support. I see it all the time. And I don't understand it. I don't know if people are so busy and they look at the head note and don't read the case, and the case doesn't really support what their position is. I kind of think that's what I get, because I see the quote from the head note, but when you read the case, it's not on point, or it may not be the exact proposition that that case is representing for the facts of that case. Or if it's a situation where you may be cutting and pasting from another order. But I see that a lot. And my career law clerk has taught legal writing at UNL for over 15 years. And I keep going back to her and I'm like, I'm assuming that you tell them to read the case, right? And of course she says yes. And so, but it's something I see more and more. And it's concerning, because through all of this, just so you all know, you're building your reputation, not only with other lawyers, but with the court. So if I see that from a lawyer, then I question that every time they give me a filing. I don't know whether it's right or wrong. So everything has to be checked, and everything does get checked. But it's frustrating. And it's the same thing for the law clerks. If the law clerks see that, they're not going to trust anything that person ever submits. So you need to really keep in mind that obviously you can build up your reputation, but you can destroy it in about 2 seconds. And so that would be number one. And then number two, kind of the other thing would be either arguing state facts in the case or statements from a case, but it's out of context. And so you don't really want to do that either. And then if you have contrary authority, and this gets into, I'm sure the client will say, why would you put that in a brief? That doesn't help our side. We're going to find that law. And I cannot tell you how many times there's something directly on point that's contrary that nobody brings up in their brief. And that's the other thing I talk to my law clerk about. Are you teaching them that? Because that's how I was taught. That's what you're supposed to do. And then explain why either it doesn't apply in this situation, or maybe the court needs to think about it differently. But more times than not, it's not included. And then we find it, and I don't know if people are hoping we don't find it, or maybe they're playing to the client, and I understand that perspective. I practice law, obviously. I understand that perspective, but I will tell you again, you've lost all credibility with the court when we see that happening. And so in the end, does that benefit your client? Probably not. Probably not. So just keep that in mind. And then obviously, don't invent the law. If there's no existing law in point, I talked about this kind of, say that, and then use any relevant and available legal reasoning in regards to that. Just hit it right up front. Obviously, we can respect that a lot more than trying to circle around the issue. And then you haven't fully explained or clearly explained why what you're arguing is justified or supported. So keep that in mind. The courts not only expect you, and we're going to talk about being professional and respectful, not only to other lawyers, but also in your brief writing. So, or in your motions to the court. And when you're on a discovery dispute call with the court and you're getting irritated with the other side, that doesn't mean you start arguing back and forth. That's the other thing we hate stopping, but obviously we will stop that. And I understand individuals can get frustrated and individuals need to advocate for their position, or if they think the other side is not giving the full picture of what happened. I understand all of that. But there's a way to do it professionally and a way to do it not so professionally. And I think you need to think about that. And in particular with pro se individuals. Pro se parties tend to get triggered or upset by arguments that are made in a motion, in a brief, at a hearing. And they may go to a level that your reaction may be to respond at that level, but you are professionals and the courts don't expect you to respond in that way. We understand the frustration. We understand the difficulty that can be imposed on you in this regard. It's the same for the court. I'll be honest. It's the same for the court sometimes. Because they don't understand the rules. They don't understand the other side's advocating for their client just as they want to advocate for themselves. And so it can be clearly unprofessional. Now, if we're on a phone call, we're not going to allow that to happen. But just because they've said something in their written submission doesn't mean that you should stoop to that level and do it as well. So keep that in mind. Again, building your reputation and kind of being above that is more helpful to you and your client. The other thing to keep in mind, and this kind of goes back to, is it really necessary? Is this something we really need to file? Should we maybe compromise on this? And that in regards to a pro se person, and think about the court's responsibility and what we have to do in reviewing pro se pleadings, which is we have to liberally construe that pleading. And because of that, they are given a little bit more grace than what a lawyer should file. I understand the argument that it shouldn't be that way. They've chosen to proceed without a lawyer, but that's the reality of what we have been directed to do. And so we do have to liberally construe their pleadings. So think about that when you're filing a motion to dismiss. Does the pleading, is there enough there with that, the court liberally construing it for it to go forward? Because maybe, because if that's there, then you're probably going to lose the motion to dismiss, and maybe the case can just proceed rather than sitting there for 60, 90, 120 days, because usually the pro se person needs more time to answer the motion that was filed. So, and again, most of the time they will get an extension. So it may delay the case longer than your client may want. So just think about that and whether it really needs to be filed. And then think also about the standard of review in regards to summary judgment. So, for example, if you're going to have the court or ask the court to make credibility determinations, then summary judgment's not appropriate. So, because the court can't do that. So, is this a case where summary judgment really needs to be filed? So, think about that, because again, you get into, well, you're not supposed to be filing things that there's not a sound basis for. So if you're asking the court to do something that it can't do in regards to that motion, think about, then you should be thinking about whether that motion should really be filed. The other thing I would say to think about is motions to compel, and we talked about that briefly, and that you need to meet and confer, but really think about whether those need to be filed and or is there a compromise? Because again, and I can't say this enough, no one's going to get 100% of everything they want. It's just not reality once you come to the court. It's not going to happen. So be thinking about that and whether it's necessary. The other thing I want to talk about is motions for sanctions. I understand that they are necessary at times, but obviously the court uses it is an exceptional thing for the court to order sanctions. So it has to be an exceptional situation where that's probably going to happen. So is it necessary? I also don't like to see it. And unfortunately, as a magistrate judge, I saw these all the time. One lawyer says, I'm going to go to the court and I'm going to ask for sanctions. And I always end up seeing those emails. I do not dispute there are situations where it is appropriate, but those are few and far between. And once you throw that out, and particularly in the beginning of a case, the relationship with that lawyer is, in the divorce term, irretrievably broken usually at that point. And as a magistrate judge, I would see what that would do to a case, how it delayed a case, how it did not, the parties just absolutely could not work together to do anything. And so I ask you to think about whether it's appropriate to file that, to threaten the other lawyer with that. And I use threaten lightly, but I mean, obviously, if you're writing that email, you're telling them you're going to do something. Think about whether that's really, really necessary in this case. And is that going to get you to the end goal of what you want to do and what your client's objectives are? And if you need to contact chambers, and I think those that have worked in federal court, our magistrate judges in this district are very accessible. They are there to help you, to move your case along, to try to resolve conflicts between the lawyers, which sometimes really the clients, but the lawyers, to try to keep the case moving and as efficiently and as effectively as possible. They're there to answer your questions. But if it is something of substance, remember, if you send an email, everybody has to be on that email, including a pro se person. If you send a letter, that letter needs to be sent out to everybody, including a pro se person. If it is something of substance and you don't do that, that's an ex parte communication, which is unethical for you to do. And certainly the court cannot participate in that in any way, shape, or form. So we expect, if you're going to contact the court, that you know that rule. And so we are there to help. And the magistrate judges can be tremendously helpful to the bar to keep the case moving, but just make sure that any communication, that all parties are aware of that communication. Oops, all right. So contacting chambers, we talked about that. So I'm going to talk about where you can find the things we talked about. And here, right here, local rules, all of our local rules are right here. So you can find all of those. This is the main page of our website. If you want to find the case management practices, you hit the attorney button. That will end up taking you, you'll hit the judge's information button in the drop-down menu. That will take you to all the judges' pages. And here's the civil case management practices. If you hit that, well, maybe, well, if you hit that, there we go. Then it will take you right there are the case management practices. Right underneath there is the Rule 26F report calculator. Has anybody used that or even know what it is? Yes? Okay. I don't see very many hands. We spent a lot of time working on this when we did the case management practices, and we've talked about it, but we haven't really talked about it in the last few years. So, for example, if you want to get to trial by a certain date, then you can put in, for example, the judges need so much time from summary judgment until your trial date. So for you, if you go into that calculator, if you want your trial date to be, I don't know, June 5th of 2026, you can put in that trial date and it will backfill all of the dates for the Rule 26 in order to get to that trial date. Now, obviously, you're going to have to meet all of those deadlines to get to that trial date. But it can be a tremendous tool or a helpful tool. Or if you want to see if we do summary judgment by this date, then when do we think trial is going to be available to us? It will tell you that as well. You can put in the summary judgment deadline. It'll give you your trial date. Or you can put in a trial date and it'll backfill everything. And then you can kind of see whether that's going to be realistic or not. But that is a tool that you can use. The other thing I would say about our website, so all of the district judges and magistrate judges are on this webpage. And I'm going to give an example. Judge Bisher has on his civil and jury, non-jury civil case practices, trial practices, as well as some of the other judges do as well. I encourage you to look at those. You may want to look at those in the beginning of the case, the middle of the case, as the case is getting towards trial, because there are a lot of deadlines in there in addition to what are in the rules. And so the magistrate judges should be telling you when you have conferences with them to look at these rules, make sure you're aware of them. But I do encourage you to do that. And those are updated with any changes. So those can be tremendously helpful as well. But again, we have a lot of resources on our webpage. The rules, case management practices can answer the majority of your questions. And if that still doesn't answer it, reach out to the magistrate judges. They are there to help you to keep your case moving. I think I've talked for a half hour, which was my time. And I know there's a break, but if you have any questions, I'm happy to answer any questions.
Everyone needs the information, all right? Thank you. All right, set. What do we change slides and Joel? You ready to go?
Yeah. Congratulations, Myron. All right, I think we're ready to start the second half of our presentation. Before I bring Patrick Pepper up, I want to just make a comment on the title of our presentation. Generally, my presentation is generally Sorry. That better? My presentation is generally recent developments in Iowa and Nebraska in terms of ethics rules. That title remained the same this year, but we're going to do something a little bit different this year. Patrick is going to take the first half of the rules of professional conduct. In May, he's going to take the second half of the rules. We're going to address some of the key rules that are coming up before the courts and occurring in decisions, so that you're familiar with those. It's rather than get into the decisions themselves, it'll be kind of a primer on the rules of professional conduct that you experienced in law school, that you're bound by today. But hopefully it'll be insightful, and make it a living document that you can get involved in, and you can pick up and read it yourself and understand where we're at. And if you've got a situation that you think there's an ethics problem, you can look it up yourself. Then we'll get into, in my presentation, we'll get into what I call the fastest 5 minutes in ethics, where we go through some of the changes that have occurred, one of which will be on succession planning. That will be the last thing that I address. That is something that Iowa has for lawyers for the last 3 or 4 years. I think they've been involved in succession planning for lawyers. Nebraska is just getting into that, and in November 1st, we got our effective date for succession planning. So it's something that we're all going to have to deal with one way or the other. And so I'm going to make mention of that as well. So without further ado, let me make the introduction of Patrick. Patrick is a civil litigator in McGrath North. He has been the lawyer for almost 20 years, so he's coming up on his 20th year anniversary as a lawyer. He's a graduate of University of Nebraska in Lincoln in 2002, graduated from Creighton School of Law, cum laude in 2005. Patrick will be addressing the first half of the rules of professional conduct. Please welcome Patrick.
Thank you, Scott. Briefly, Scott has led this process for a number of years. He is graciously shifting some of the work onto Maggie and myself and other members of McGrath North. But I would be remiss if I didn't recognize the amount of work that Scott has put into this program over the years and the value that he's provided to the Omaha Bar Association, McGrath North, some of you in this room as clients, when you get involved in ethics issues. Scott's not going anywhere, but I did want to thank him for his years of service on this, and if we could give him a round of applause. So as Scott mentioned, I'm going to talk about the first roughly half of the model rules of professional conduct. Those are broadly described as the preamble, the rules that govern the client-lawyer relationship, the rules that govern us as counselors, and the rules that govern us as advocates. In the preamble, after listening to Professor Fouché discuss sort of the client run amok, I really was happy that I had read the preamble to these rules. The preamble is nearly aspirational, but it does inform sort of what the rest of the rules instruct us to do. As lawyers, we have an attorney-client relationship. That's obviously important. We serve as the counselor to our clients, and we serve as their advocate. It's important to recognize and to appreciate that when we go through these rules, all of those roles are impacted in one way or another. Some more directly with certain rules and certain factual circumstances, and some less directly, but they really do permeate the entire series of rules. We wear oftentimes 3 hats if you think through the model rules and the way they instruct us to behave. We have to represent our clients, whether we're advocates, whether we're negotiators, whether we are the person who gives candid advice to a client to help them choose a course of action that complies with the law. We're also officers of the legal system, officers of the court. We have to, as ethical lawyers, be willing to be zealous advocates, but also being willing and duty bound to uphold legal process. And we're also still public citizens walking around every day, but we do have a special responsibility for the quality of justice. When you're confronted with an ethical issue, I think it's appropriate and sometimes even advisable to look at this preamble, and it might help you guide yourself through the way to interpret this. As I think Dean Fouché or Professor Fouché, some of these are easy calls, but a lot of these things and a lot of these issues that come before us occupy some portion of the gray area. It's a portion of the tension between being a zealous advocate and complying with the legal rules. It is, you may have a client that wants you to argue for law that isn't supportive, and maybe you end up citing a case for a proposition that it doesn't support, and you're in front of Judge Bezos. The rules and the model rules help us as lawyers retain more autonomy for self-regulation and self-governance than most professions. We are unique in that we are the only profession that gets to appear in front of the judicial branch. The judicial branch largely controls our profession without other government intervention, largely. But that's why compliance with these rules is important. It is self-executing upon us, but it's also incumbent upon us to hold each other accountable to compliance with the rules. And that's important to keep us as self-regulatory as possible, particularly given some of the rules that lawyers have to take relative to government actors. The rules are largely rules of reason, so they call themselves. By that, they mean you're going to exercise your judgment. There are many, if you look through the rules, there are many shalls, there's shall nots, there's mays and may nots, and there's shoulds. But almost always, when you find yourself in a situation, the one definition that becomes very critical is informed consent with your client. That's right out of the definition section of the model rules. And informed consent requires a full disclosure of the adequate information about the material risks and reasonably available alternatives to a course of action. There's even judgment inside of what constitutes informed consent. If you're talking to the general counsel of a Fortune 100 company that regularly deals with conflict of interest waivers, the informed consent and the disclosure is a heck of a lot different than if you're talking to a sole proprietorship of a business who knows nothing about conflicts of interest. So the disclosure of what's material and what the alternatives are is something that we each have to go through whenever having an informed consent discussion with the client. What I'm going to do now is sort of, to borrow a phrase that I think was used pejoratively, and I'm going to use it nicely. I'm going to drive by all of these rules. And I want to highlight them because we all encounter certain ethics rules in our day-to-day practice. Litigators know candor to the tribunal, or should know candor to the tribunal is a key ethical rule. Litigators probably don't get faced on a daily basis with business transactions with your client, whereas transactional lawyers may see that more frequently. So the purpose of this is to just go through the rules, remind you that they're there, and then when you go back to your regularly scheduled programming of life, you can remember that, oh yeah, there was this rule that maybe I should look on. Competence. We all have a sphere of competence, some of us broader than others, and many of you broader than me. If someone were to call me on a capital murder case, I would have to turn it down. I don't have the competence for that kind of case. I've never done one. I wouldn't know where to start, and I'm not taking somebody's life in my hands. that can be a difficult decision for certain lawyers to make. And that's where some of the tension of the practice of law can come in. You still need to make a living, but you need to know your sphere of competence. So it's important when your case intake or your client intake comes in that you can adequately handle the type of work that's in front of you. Scope of the representation. This rule is an important ethical rule. It's also an important rule for your sanity. At the upfront of your engagement with your client, you should have a clear understanding, and it's, while not ethically specifically mandated, it's probably advisable to have a written engagement letter specifically setting forth the scope of your engagement. One client may think you are that person or that company's lawyer for everything under the roof, and you may think you're only that person's divorce lawyer. It is beneficial to clearly define your scope and make sure the client knows it. Diligence. I think it is fair to say that if we look at the ethics opinions, we look at the decisions from the Nebraska Supreme Court when dealing with attorney discipline, that procrastination and lack of diligence in your cases is one of the biggest trouble spots for lawyers ethically with their clients. Everybody's got the press of other business. Everybody's got lives they need to live, but staying on top of your client's matter is both ethically required in addition to being available. The glove that goes with that hand is the communication. It is incumbent ethically upon us to communicate material facts, to communicate changes, to communicate decision on means and methods to hit the client's objectives. And the big one, to answer the client's questions with diligence. Fees. The ethical rule, the model rule, lays out the fee formula, and I don't mean that by an objective amount of numbers, but the things that are to be considered when determining whether a fee is reasonable. There's loads of litigation over what's a reasonable fee. There are fee applications, oftentimes in federal court cases, where fees are more readily attainable in cases where this particular rule of ethics also becomes sort of the substantive guideline for how the fee is going to be determined. But I think it's important to look at that and make sure that when you're charging a client a fee, you understand why that fee is what it is and how it comports with the ethical rules. Confidentiality is last rule on this slide. Confidentiality is both the ethically obligated, but there is also the concept of the attorney-client privilege. They are two separate but related concepts. We have a duty to keep all of our clients' information confidential unless impliedly authorized as part of the engagement, expressly authorized after informed consent, or necessary that we deem in our own judgment for the exceptions for this rule, which are essentially the crime fraud exceptions or for the safety of people of the public. The example that the comments to the rule give, which is a fair but extreme example, you have a client that's dumped something toxic in the city's water supply. You are allowed under the ethical rules to disclose that to prevent the injury that is likely to occur from people drinking toxic water. Another exception to the confidentiality, and it is somewhat, it's an intuitive exception, but it's expressive there. You are allowed to seek legal advice for compliance with the ethical obligations. Therefore, if you're presented with a quandary from a client that you don't know where you're going to land on, you are allowed to go to a lawyer and ask for advice of compliance with the ethics. Conflicts of interests. I'm going to deal with all of these in sort of one discussion. I think most of us understand that we can't sue our clients, but conflicts of interest can go beyond that. A conflict of interest is both taking a position adverse to your client, and it can be taking on a client despite the fact there's a material limitation in your representation. If you have a strongly held belief that what the client's objective is improper or repugnant to you, you shouldn't take the case, even if their objective is legally allowed, but you have a material limitation. Or if you have a client with an interest, maybe it's not ripe in litigation, but you have a client that's a competitor and doesn't want that competitor to succeed, you may have a material limitation. And those conflicts are important to screen up front and to understand before you find yourself 6 months into an engagement and realize that you have a material limitation. Section 1.8 or 3-5018 has some specific conflicts that are identified. Those can be the situations like do a business transaction with your client, or certain types of contingency fee agreements. I would just encourage you all to refresh yourself on 1.8 and the specific conflicts there. Former clients do have rights and expectations relative to conflicts of interest and confidentiality. If you have a former client, you are prohibited from taking a matter adverse to that client that is the same or substantially related to the matter that you had for the client when they were your client. Even if they fired you and 2 years later, the matter comes back up and you've still got the confidential information from 2 years ago, you will be prohibited from taking, and you should decline to take that type of case. This former client rule also comes up in conjunction with 1.10, the imputation of conflicts, when lawyers move firms. From time to time, lawyers will change firms, and while they didn't have any exposure to a case at their old firm, their new firm may be on the other side of that. There are instances where that can be addressed either through waivers, or perhaps there's not a knowledge of 1.6, but whenever a lawyer switches firms, the former client rule and the imputation rule become quite relevant. These rules are specific. 1.11 and 1.12 are specific rules for former and current government employees and officers, and former judges, arbitrators, and mediators. If you find yourself in that situation, I just point this out, that these rules will govern what clients you're allowed to take without conflicts of interest. The last rule on this slide is the organizational rule. This rule is the rule that deals with the fact that organizations are often our clients, whether it's a company, a partnership, a nonprofit. All of those organizations have to act through individuals, constituents. There will be instances where those individuals will want to take action that is contrary to the interest of your client, the organization. This is a difficult issue for many lawyers because you feel as if your client is the individual you're talking to or emailing. But it's not, and we have to remind ourselves that the organization is the client. There are ways to deal with these particular sticky wickets. Oftentimes what's required is the so-called reporting up. If you're dealing with a marketing executive who blatantly wants to engage in false advertising, it's going to expose the company to tremendous amounts of liability. You have to take a hard look at this rule and decide whether you need to go over the marketing executive's head. These are tough calls, and they're ones that are going to require a lot of thought and judgment. Clients with diminished capacity, another tough one, but you should just know it's out there. If you encounter a client with diminished capacity, there are ways to get through it, guardian ad litem, etc. But it is good to know that we do have ethical guidelines on this topic. Safekeeping property. Briefly, this is the trust account rule. I think we all, any of us that read the Friday opinions, know that the quickest way out of this profession is to mess around through trust account. So I think that'd be a good, it's a pretty simple rule to know and follow. It's a pretty simple rule to know. Declining and terminating representation. A good screening process up front, knowing your conflicts, knowing if you're materially limited in representation will help avoid some of the termination of representation. But you will be faced, and there are rules that give you guidance for when the circumstance arises that you're faced with an ethical conflict that you cannot continue the representation. What I will say on 1.16, you're still going to have confidential information. You're still going to have information that is protected by Rule 1.6, and you'll have to adhere to that. So even if you decline to take on a client, if they've burdened your brain with confidential information, you may be prohibited from taking something adverse to that prospective client, notwithstanding the fact that you never had the relationship. So again, upfront screening, limiting what information you get at that upfront is a valuable step, and will save you some headaches in the future. Rule on sale of law practice. I think if you're going to go through that, consult this rule. Prospective client, similar issue about confidential information. The next set of rules are about counselors. The advisor component of being a counselor, candid advice. Sometimes you can't pull punches and you have to give bad news. That sometimes can be the harder part about being a lawyer, but it's ethically required. Can you give advice for evaluation for use by third parties? Maybe. You need to look at this rule. You need to make sure it's not contrary to your client's interests, that you may need to get informed consent. The client may tell you they want you to do it, but know that it can happen, but this presents an ethical issue, and you should spot this when somebody asks you to give advice for a third party. Rules for lawyers serving as third-party neutrals, arbitrators, mediators. If you find yourself in that role, there are ethical rules to consult here. Advocate. Probably the push and the pull of the tension of being a lawyer inside of these rules. We all know the substantive rules of Rule 11 and 25.824 on state court. We don't bring frivolous claims. We don't file things to harass people. We don't prolong discovery or litigation for the sake of gaining an advantage. But that's not just state law or federal rules of civil procedure. It's also an ethical requirement. Candor towards the tribunal. I hope I'm not one of the lawyers that submitted a brief with a bad citation in it, but that's a pretty straight candor to the tribunal issue. I don't think that's really a close call. So if your briefs aren't getting proofread, to make sure you're getting the case citation right, you should probably revisit this rule and revisit your editing practices. Fairness to opposing counsel and the opposing party. This is the turnover of the discovery that's been asked for, that's properly asked for. This is answering truthfully the questions that are presented in written discovery. This is not hiding things. This is participating fairly in the civil process. Impartiality and decorum of the tribunal. Judge Bays has hit on it. Ex parte communications, trying to influence juries, trying to influence judges, not appropriate. Trial publicity, there's some tension there with that rule in the First Amendment, but if you're going to be in front of the media on your cases, I'd suggest you give this rule a review and make sure you're comfortable with what you're saying, what you're doing. Is it going to run you afoul of this? Lawyer as witness. This rule is oftentimes misunderstood. Lawyers oftentimes do serve as witnesses. Members of the same firm serve as witnesses, even though they're partners, the one trying the case. The limits on being a witness are fairly specifically described. So if you find yourself in the situation where you may be a witness or your partner may be a witness, if you're the litigation side of your law firm and your transactional side has something that's going to dispute, this is a good rule to refresh yourself on, but it's not an automatic bar. Special responsibilities of prosecutor. Prosecutors will know these rules or should know them. Similarly, in the last rule is this advocate and non-adjudicative proceeding. City councils, legislatures, things of that sort, where you appear on behalf of a client. It's not a judicial branch process. You are still a lawyer. You are still ethically required to behave like a lawyer. Honesty, respect, those types of just baseline expectations and ethical obligations apply, even if it's outside of the judicial branch. All right. Thank you. I will. That is it. I got it.
Thanks, Patrick. One thing I wanted to add as a postscript to Patrick's comments, there's one party that's involved here that he really didn't mention, but we need to keep it in the forefront of our thoughts and processes concerning any litigation, and that's the client. If you got an ethical violation by a lawyer on the other side, or something you perceive to be an ethical violation, say there's a conflict of interest, it's perhaps a no-brainer, perhaps an obligation on your part to go forward with a motion to disqualify or to put that lawyer, his client, on notice that there's an ethical violation here. But you also should tell your client, because your client is the one who pays the bill. And it could be that if you explain this, what you're going to do to your client says, no, don't do that. Well, that may be a problem for you in terms of your ethical responsibilities. Maybe the client likes to go with a different lawyer. Maybe you need to withdraw. Maybe the client goes in a different direction that moots the issue that's under consideration. But just keep in mind, with respect to any ethical violation that you perceive, make sure you get your client involved. Make sure you keep them involved throughout the process, because they're the ones paying the bill. And if they don't understand what you're doing when they get a bill, they're going to be calling you on the phone and saying, what's this charge for? What's that charge for? Those are tough conversations to have. So keep that in mind as you go forward. Now, for the second half of the rules of professional conduct, Maggie Rossler is now going to address you and bring you up to date on some of those rules. Maggie practices mergers and acquisitions and corporate law at McGrath Hill. She's a graduate of the University of Kansas in 2015. She's a graduate of Creighton School of Law, cum laude, in 2019. Maggie will be speaking on the second half of the rules of professional conduct. Please welcome Maggie.
Okay. So as Patrick said before, I'm just going to try to give a high level overview of these rules. And before I start, I do want to say that the Battle of the Bartenders that I'm participating in will be in compliance with the rules of professional conduct. But because you are here, you are ethically obligated to vote for my drink. So thank you for that. So I'll start on this. The first section is about transactions with persons other than clients. So a lawyer cannot knowingly make false statements of material fact or law to a third person. I think we all learned this from our parents growing up. Don't lie. And a lawyer must disclose a material fact to avoid assisting a client's criminal or fraudulent act, unless there's a carve out in Rule 1.6. Know that a lawyer also has a duty to correct a false statement, even if it's going to hurt your clients. If you find out later on down the line that a statement that you made is now untrue, but it isn't good for your client, you still have to correct that mistake. Communications with persons represented by counsel. I think we all know this one, but a lawyer must not communicate about the subject of representation with a person who's known to be represented by another lawyer. And communication is prohibited even if the person represented initiates it or consents to it. I think email makes this rule particularly hard when two sides to a case or a business acquisition are friendly with each other and want everybody to be involved in all of the communications. So you have to be careful with how you're responding and who you're CCing and the types of communications you're making when all of those parties are in one email. And know that the form of communication doesn't matter. So emails, letters, whatever you're stating has to be treated, or however you're stating it has to be treated the same. The next is dealing with an unrepresented person. So a lawyer cannot imply disinterest when dealing with an unrepresented person, but a lawyer also can't make a statement to an unrepresented person that would lead the unrepresented person to believe that the lawyer is acting in that individual's best interest. So there's a bit of a gray area there because you can't act totally disinterested, but you can't go so far to make them believe that you have their best interest in mind. So you should also correct misunderstandings about your role and avoid giving legal advice to them. Make sure that you're saving those communications. If you send an email to somebody who's unrepresented saying, this is not legal advice, I'm not your attorney, I'm just passing this along to you, make sure that you save those types of correspondence. So that way, if it comes back, it's not a he said, she said ordeal where you're trying to fight about what was said. The next is respect for rights of third person. I think this is another one that your parents would have taught you, but a lawyer must not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. One that happens with some frequency is receiving an email from another lawyer that you aren't meant to receive. So that falls underneath this rule. Make sure that you notify that sender that you received that email and that you're deleting that email, but they need to know that they obviously sent it to the wrong individual. The next grouping is law firms and associations. So this one is talking about the responsibilities of a partner or a supervisory lawyer. So you have an associate partner relationship. Partners and lawyers with that managerial authority have to ensure that the firm has measures to confirm compliance with the rules of professional conduct. Luckily, McGrath has Scott Paul, so I believe he is our policy and procedure, but supervisory lawyers have to ensure subordinate lawyers conform to the rules as well. A supervisory lawyer is responsible for another lawyer's violation if they order or fail to take remedial action when you're aware of the conduct. And then the responsibilities of a subordinate lawyer, they're bound by the rules even when they're acting on behalf of another attorney or on behalf of a partner's direction. So while a subordinate lawyer customarily would pretty much do what they're told by the partner, they cannot knowingly act as instructed if they know that it violates the rules of professional conduct. The next is regarding responsibilities regarding non-lawyer assistants. So lawyers with managerial authority must ensure that non-lawyers' conduct aligns with professional obligations. So although your secretary or assistant or paralegal might not be bound by the rules of professional ethics, you have to make sure that they are acting ethically so that it doesn't come back to you. And then professional independence of lawyers. Lawyers cannot share legal fees with non-lawyers with specific exceptions. And you can't form partnerships with non-lawyers if any activities involve practicing the law. You cannot allow third parties to direct or regulate your professional judgment. I think this one gets hard in the corporate area when you're bringing in other professionals like financial advisors, CPAs, who want to go in a specific direction, but that direction isn't the most legally sound direction for your client. It might be what's best financially for them, but you have an obligation to tell your client that that's not your advice to them legally, even though it might be the best financial decision for them. And then lawyers cannot practice in a firm where non-lawyers have ownership or control. I think we all know this one, the unauthorized practice of law, multi-jurisdictional practice. If you are not licensed in a state, you cannot practice law in that state, except for certain conditions or except for certain exceptions. And some lawyers can provide services to their employer or is authorized by law without a general admission in that state. And then 3505.6 regards non-competes. Lawyers can't make agreements that restrict their right to practice after leaving a firm, except for retirement benefits. So except for in the case of a retirement. And lawyers cannot agree to practice restrictions as part of a client settlement. Um, 3505.7, responsibilities regarding law-related services. This is an area where I say it's always best to kick it to the expert. Lawyers are subject to the rules when providing law-related services that are not distinct from legal services. Law-related services are those that are related to legal services, but not unauthorized. So I think sometimes in the business context, when you're saying, okay, I think this tax situation or this tax structure might be best for you, while that, is advice for them, it's technically not legal advice, and you should always be telling them to advise their accountant or their CPA or their financial advisor to make sure that that works for them and let them know that you're not providing them tax advice. The next set of rules is about public service. So we all know that we should aspire to provide some pro bono legal services to those of limited means and organizations serving individuals with limited means. You should provide these services without expecting a fee in return. And if you do get a fee in return, it should be given back to that individual or donated to relevant organizations. Government and public sector lawyers have some different restrictions in this area, but you can fulfill your pro bono responsibilities in alternative ways. Law firms should encourage and enable pro bono work among their lawyers, but know that it's not enforced through disciplinary services or disciplinary processes. So although sometimes it seems hard to juggle the billable hours and just general life, on top of that, pro bono hours might seem like a lot to do, but it's good for all of us to give back. And the ABA recommends a minimum of 50 pro bono hours of services annually. This next one is about accepting appointments. So lawyers shouldn't avoid tribunal appointments or appointments from the court unless it would violate the rules of professional conduct, impose unreasonable financial burdens. So really, if you're getting asked to do something, you really should accept that appointment unless you have a really good reason not to. Appointed lawyers have the same obligations as retained counsel, including the duties of loyalty and confidentiality. Lawyers can serve in legal service organizations, even if that organization serves interests adverse to your client. However, you cannot participate in decisions that conflict with your client obligations. And participation in the organizations cannot create a client lawyer relationship with the person served by the organization. Sometimes this comes into play if you're serving on the board of an organization. You're not that board's lawyer. You are just there with your regular public person hat on. Um, 6.4 kind of goes along with the last slide, law reform activities affecting client interests. So again, you can participate in law reform organizations, even if they affect client interests, but you do have to disclose it to a client if it affects, if it will benefit them materially or affect them materially. And lawyers serving, providing short-term legal services under nonprofit or court-ordered programs are still subject to conflict of interest rules, only if they know of a conflict. So I think here of the tenant assistant project, if you ever do that, you go over to the court, you meet your individual who you're going to represent. You obviously don't have enough time to run a full conflict search like you would at your law firm. And so there's exceptions here that you can still represent that individual for that short duration. And the only conflict issue that could come up is if you know right away that there is a conflict, then you cannot represent that individual. Nonprofit and court annex limited legal service programs. So again, you can Oh, I just said that one. I'm sorry. And then information about legal services. So these are kind of interesting to me because I think the advertising and marketing that's going on now, advertising and marketing is so big on social media, and it's interesting to watch different law firms navigate these rules while still trying to promote their business. So lawyers cannot make false or misleading communications about their services, which could include material misrepresentations or omissions. All communications, including advertising, have to be truthful and they cannot be misleading, even if the statements are technically true. So if you have a phrase that says "we win," yes, technically you win a lot of cases, but that could mislead an individual to think that you win every single case that you get. Misleading communications can include unsubstantiated claims or comparisons. So you might need to have a disclaimer on there that, yes, we won this case and our case is similar to yours, but it's a different set of facts and circumstances. And so just because we won this case doesn't necessarily mean we're gonna win yours. And then firm names and professional designations cannot imply false connections or mislead the public. So lawyers can advertise through various media. I know lots of law firms and lawyers post on LinkedIn, but you still have to adhere to the rules against false or misleading communications. Your advertisements have to include the name and address of at least one responsible lawyer or the firm name. Lawyers cannot pay for recommendations except for reasonable advertising costs, legal service plans, or qualified referral services. Reciprocal referral agreements are allowed if they're not exclusive and the clients are informed about it. So to break it down, your ads have to be truthful and they have to identify the lawyer or the law firm responsible for the ad. Lawyers also have to retain a copy of their advertisements. So if anybody ever came back, you have to be able to produce that copy for a specified period of time. Be careful, again, with advertising something like a big win. Make sure that the public knows or the prospective client knows that the win was based on a specific set of facts. This next section is about direct contact with prospective clients. So I think we all know that you can't directly solicit a potential client for pecuniary gain, with certain exceptions. So if the prospective client is a lawyer or it's a close friend of your family, there is also an exception if that individual was a former client. Solicitation is also prohibited if the prospective client has basically told you to stop calling them. So I think of it as the do not call list. If they tell you to stop talking to them about it, you can't continue to talk to them about it. Written or electronic solicitations have to be clearly marked that they're advertisements, unless they're directed to certain individuals. And lawyers cannot participate in legal service plans that use personal contact, or lawyers can participate in those, provided they don't own or direct the organization. Communication of the fields of practice. So we can all say the type of work that we do, but you can't claim to be a certified specialist unless you are actually certified by an approved organization. So you can't just say, I'm the best lawyer, even if you think you are. But you can put down designations like the American College of Trial Lawyers or super lawyers or other certification designations. So the final grouping is maintaining integrity of the profession. And I think that's pretty much what we've been talking about the entire time. And one of the main reasons behind having these ethical rules. So from the very beginning to the very end, your bar admission, you can't knowingly make a false statement of material fact or fail to disclose necessary facts in a bar admission or in any disciplinary matter. And you cannot make false statements about the qualifications or integrity of judges or candidates for judicial or legal office. And lawyers running for judicial office must comply with the Nebraska Revised Code of Judicial Conduct. So if you're ever looking to take judicial office, take a good look at those. These next couple of rules aren't necessarily the most fun to talk about, but our profession is stressful and can lead to mental health or other issues that can be detrimental to an attorney or their client. So lawyers have to report known violations of the rules of professional conduct by other lawyers or judges that raise substantial questions about their fitness. The rule does not require disclosure of information under Rule 1.6 or gained through approved assistance program. And we have a great assistance program, the Nebraska Lawyer Assistance Program, NLAP, and the website can be found on the Nebraska Bar Association's website. I have listened to a couple of those presentations that NLAP gives, and I think it's a great way to refresh on the resources that we have. They also will take calls if you ever have any question about an ethical matter, and they'll walk through it with you. And there's an entire page on the website that helps navigate getting help for someone else if you believe that somebody else in your firm, whether it's a family member, somebody else in your firm, or opposing counsel needs assistance. And so obviously that rule also encompasses not only mental health issues, but misconduct, which can be a variety of actions or omissions. Professional misconduct includes any violation of the rules of professional conduct, committing criminal acts that reflect adversely on a lawyer's fitness, or engaging in dishonest or prejudicial conduct. So although a lawyer is personally answerable for criminal laws, a lawyer is only professionally answerable for those offenses that indicate lack of characteristics relevant to the laws of practice. So you could be a crappy individual, but still be allowed to practice law because it doesn't violate the rules of our professional conduct. And again, I think it's important to point out that lawyers are not only obligated to report the misconduct of opposing counsel, but also those individuals who you know more, who are your colleagues, law partners, or even family members. And my last rule is disciplinary authority. So if you're admitted in the jurisdiction of Nebraska, you are going to be subject to disciplinary action in Nebraska, regardless of where your conduct occurs. This rule aims to minimize conflicts between different sets of professional conduct rules, and it protects lawyers acting reasonably in uncertain situations. That's it.
Thanks, Maggie. You know, it's one of the things that we do that we probably should do more often is give you an overview of the rules and how they apply to various circumstances that we run into. But that would be boring as hell. And so we should do it more than once every 20 years. We should probably do it every year. So we'll probably do it again in 5 or 6 years. But it's informative. I'm sure each one of you, as Maggie or Patrick read their outline to you and went over some of the things that they were talking about, each of you looked at it and thought, yeah, I run into that before. Yeah, there's that rule. I knew it was out there somewhere. So hopefully it was helpful to you. What I've got to do is just for the last 5 or 10 minutes, since we're rolling right along here, I'm going to deal with our fastest 5 minutes in ethics. And that's kind of a traditional thing that we've done in the past. So the first thing I want to talk to you about is MCLE credit. The hours have changed in Nebraska. The prior rule was you can only carry over 5 CLE credit hours into the next reporting period. That's changed now to a certain extent. Now, as of January 1 of 2024, you can carry over up to 10 hours of credit into the next reporting period. So you got 5 more hours you could carry over, which is a good thing. Another change to the rules, only in-person credits may carry over with the prior rule. So the distance learning credits did not carry over. Now both in-person credits up to 10 hours and distance learning credits up to 5 hours may carry over, subject to the rules annual limitations on credit type. So when I say subject to the rules annual limitations on credit type is distance learning or in-person learning. One is 10 hours maximum, the other is 5 hours maximum. The prior rule was distance learning credits may not carry over at all. Now up to 5 hours of distance learning credit may carry over into the next reporting period. So those are beneficial changes that are made for a number of different reasons, since they wanted to make it easier for lawyers to attend certain seminars and do certain things that were consistent with their practice. So that's a good thing. Now, as it relates to ethics or professional responsibility, those are mandatory annual requirements and cannot be carried over. So you might think that if we just influence the court or influence the judges to say that seminars such as this have to be taken every year and can't be carried over. We didn't have anything to do with that, but we do serve as a direct beneficiary, obviously, of this. Professional responsibilities are credits that aren't carried over. So you carry over in-person learning or distance learning, but not professional responsibility. So it's 2 years every year, 2 hours every year. You need to satisfy that responsibility. The Lawyers Advisory Committee, who are they? One of the things we talked about in the past is advisory committee opinions that are written by the advisory committee, by the lawyers that are on that committee. And this gives you some indication who they are. There's 8 members of the committee. They're appointed by the Supreme Court. Each judicial district is represented on the committee, and the chairperson and the vice chairperson are selected at large. The key here is they're appointed by the rest of the Supreme Court. So I think we have good lawyers that are being recommended to serve in this capacity. Although, as you will see, you're the one that does most of the work if you're going to them asking for their opinion. Pursuant to the rule of Discipline 5, the advisory committee may render upon the request of a Nebraska attorney. So it's got to be a Nebraska attorney asking for this ruling, not a client. An advisory opinion or an interpretation of the rules of professional conduct regarding anticipatory conduct, meaning that something's going to happen in the future on the part of the requesting attorney, meaning it's something that's going to happen to you in the future. If you think that something's going to happen to you in the future, you're going to be faced with a situation where you need to get legal advice or ethics advice. The committee is there, and you have to make the request for it before they will get involved. Now, once they get involved, they're asking you to prepare and submit a statement of the specific facts upon which the opinion is requested. So this involves a fair amount of work by you to get this opinion to the point where it can be put on paper and disseminated to the bar. You've got to come up with a statement of specific facts upon which the opinion is requested, and then you need to provide the committee with a memorandum of law or ethics directing the attention of the committee to the pertinent rules of professional conduct and relevant case authority. So it requires a fair amount of research and work on your part to get the ethics committee, advisory committee involved in this in any situation that you should bring to them. And it may be that you think, this is just too much work for me. I don't want to do that. There should be an easier way out. And there is an easier way out. If you've got a question about ethics, if you've got a question about professional responsibility, I would urge you to call the Council for Discipline. You don't need to give your name. You don't need to give your client's name. You can talk anonymously and say, look, I've got this problem or I've got this situation. What should I do from an ethics standpoint? They're not going to tell you how to handle your case from a legal standpoint, who should win, what tactics you should provide. But they will give you some indication as to whether or not you have an ethics problem or professional responsibility issue that needs to be dealt with. If that's the case, they may make certain suggestions or recommendations, all on an ad hoc but informal basis and anonymous basis. But if you want something more formal, something that you can have published and something that will go into the books that can be found on Westlaw searches, you will want something from the advisory committee on lawyers in terms of their ethics opinion, most of which you're going to be drafting in terms of the facts and the law, but something that will go into the books, because any contact you've got with the Council for Discipline is going to be anonymous and won't be showing up in any published opinions or reported opinions. So I thought it would be a good example to take one of the ethics advisory opinions for lawyers and just talk about that briefly. It says that number 2403 says the attorney should comply with the Supreme Court rules by providing general information on itemized billing statements. This is relating to the billing statements that the Supreme Court, or in any statute, if you've got to supply billing statements to justify an award of attorney fees, you should never list confidential communications or attorney work product. And you should avoid revealing information that can give an insight to case strategy or in any way overall harm client's interests. Because you can't place your billing requirements or billing interests ahead of client's interests, but you need to be cautious and conscious of the fact that you don't want to give away confidential information when you're presenting something in terms of your bills or your redacted bills to the court for approval. The onus is on the attorney to file itemized statements that do not reveal information related to the representation. I hate it when they talk about onuses, but that is your responsibility to file itemized statements that don't reveal information related to the representation any more than what's necessary to get the court to understand what's been done and why it was done. In doing so, the attorney should work to protect the client's interests at all costs, and that should be your guidepost here. It should be your being concerned is that the attorneys, that the client's interests are not being affected by your request for an attorney fee. This is a public service announcement. Poor Craig Martin. There was a Craig M. Martin who was not the Craig Martin the words of Lamson Dugan, was disbarred for misappropriation of funds from a client. That's not the Craig Martin that most of you know. That's not the Craig Martin that I have dealt with in the past. That's Craig F. Martin. He's at Lamson Dugan. So I'm providing this information that, as you'd see, this happened within the last year. If Craig hasn't contacted you and hasn't told you this isn't me, don't worry about it. Now I at least give you that opportunity to know that it's not him, and you see Craig and tell him that we were advocating on his behalf. Oh, I should also point out, many of you are familiar with some of the previous seminars we've done where we had videos of attorneys doing crazy things and doing stupid things. I look for those every year. Some years I can find them, some years I can't. I don't like to do a lot of repeat performances on those. So usually if you've seen it once, you only see it, that is the only time. But we did do videos this year simply because there weren't any out there that were quality videos that we could poke fun of lawyers. And we do like to poke fun of lawyers. So maybe next year. So keep your hopes up in that regard. I mentioned this earlier, succession planning for lawyers. This has been a rule in Iowa for the last 4 or 5 years, I want to say. They've written a handbook on it. And it's something that you're going to be faced with an effective date of November 1, 2025. So it's coming up. It's going to be here before we know it. And what it means is it's there to protect your client. If you get sick, if you get a disability, if you get disbarred, one of the things that these rules will do, that the Supreme Court has adopted, is it will give the client a process by which to get representation or get their file back or to get satisfaction in one way or another. It requires, though, there be a planning attorney and a designated attorney. So each Nebraska attorney who represents clients drawn from the public, meaning you're getting clients at large, you're running a business, that's the planning attorney. The planning attorney shall name a designated attorney to protect the interests of the planning attorney's clients. And so that means you've got to go out and you've got to name another lawyer. Now, if you're in a law firm, it's one thing. If you're in a solo practitioner situation, it's an entirely different situation. Where the planning attorney is shown to be unable to properly discharge his or her responsibilities to clients due to disability, disappearance, death, disbarment, or abandonment of a law practice, this is when these rules come into play. And it's really something that's there to protect clients in the off chance that the lawyer that they have retained is not acting in their best interest or simply runs into a situation that they can't control and they need help from somebody else. So I mentioned solo practitioners. The solo practitioner represents clients drawn from the public, who represents clients drawn from the public, has to name an attorney who has agreed to be the designated attorney. So the designated attorney will work with the sole practitioner to get a limited amount of information about their practice, mainly like if something happens, where do I go? What do I look at? What drawers do I open? Where are the keys to the office? That sort of thing. Those are all things that are worked out with sole practitioners and their designated attorney. If you're an attorney in the law firm, all attorneys in firms or organizations of 2 or more attorneys representing clients drawn from the public. If if you're out in commercial activities, the public shall designate an attorney in the firm. So if you're in a law firm, if there's two of you, then you can designate each other. That makes sense. If you're in a 70-man law or 70-person law firm, you're going to need to identify somebody within that 70-person law firm to act as the designated attorney to take care of your client's situation in the event that you're not able to. There are certain exemptions to the designated attorney under this rule. If you're an attorney and you have an inactive law practice license, well, that means you're not representing clients anyhow, so that shouldn't be a problem. Active licensed attorneys who are not engaged in private practice and or do not represent clients drawn from the public. Therefore, if you're a government employee, you're not getting compensation from clients that are drawn from the public, you're exempt under this. Attorneys with active law licenses that represent clients drawn from the public and who reside out of state and no Nebraskan clients. Again, you can see that this is focused on the clients. These types of attorneys are exempt from regulation under this rule. If an attorney cannot find a designated attorney after reasonable requests, the attorney shall contact the Nebraska Council for Discipline to obtain a list of lawyers who have indicated willingness to serve in that capacity. I can tell you right now, there's not going to be a long list of people that are coming forward saying, well, I want to do this for you. But there are some. And so that's one of the things you need to look at. But it's basically the Council for Discipline and the NLAP, Nebraska Lawyers Assistance Program, that are going to be the entities that go forward with this. And they've been doing it up to this point. Finally, the Supreme Court said, that's enough. We want to keep them involved, but as on a secondary basis. And so the primary rule is if you're involved in sole practitioner situations, if you're involved in a firm that is seeking clients and obtaining clients from the public, then these are rules that you're going to have to comply with. So again, November 1 of 2025, this needs to be in place. You need to have a designated attorney if it applies to you, and a planning attorney if it applies to you. It's something to keep in mind because that date is going to come November 1, and you're going to need to have some ramp up or some work that goes toward what you're doing for the client prior to that time. Again, I mentioned earlier in regard to Patrick's presentation, one of the things you need to do is keep your client advised. Well, this is something you should keep your client advised of, is that they're entitled to know if there's been a designated attorney, not necessarily who it is or what's been told, but they need to get the comfort of knowing that there is a designated attorney that's out there that if you get a disability or if you die or if you go crazy, this is one of the things that is there to protect them. You're to provide a designated attorney and have a succession plan may be grounds for disciplinary action. Now, it's not yet, but I can see that being the case in the coming years, where the Supreme Court will more aggressively take these rules into play and saying, you're intentionally misleading us, you're intentionally trying to game the system, so we're going to discipline you. So you don't want that to be you. You don't want to be in that situation. So just keep in mind that disciplinary action is a possibility. That's all that's been left at this point, is to say it's possible, but it's most likely going to happen over the course of the next several years. And there'll be a write-up in the courts about it in the reported opinions, and then everybody will get serious about it. But I urge you to get serious about it in advance of that. And the courts give us a deadline of November 1 of 2025. A designated attorney exercising due care shall be immune from suit for conduct related to the performance of his or her duties under these rules. So if you're exercising due care, you have nothing to worry about. If you're not exercising due care and you're acting as a designated attorney, you might get sued by this client that you're now representing on behalf of, or because your planning attorney couldn't represent him any longer. It's unlikely that that's going to happen. It's unlikely that you're going to be found to be exercising something less than due care. But you should be aware that if you're exercising due care, you are immune from suit for conduct related to the performance of your duties under these rules. So that's all we got for this year. Hopefully you'll come back to the 20th anniversary next year. Thanks very much.